Miss Kim, where are you?
I'm at the office.
Oh, are you? Wow, you moved quickly.
Yes.
Well, was it interesting?
Yes.
Oh, good.
Mm-hmm.
Did you get to hear the speaker?
Okay. All right. Good afternoon, ladies and gentlemen. My name is Judge Lal, and we are going to begin with our expedited accusation calendar. This is a list of new arrests. Individuals have been recently booked at the Fulton County Jail, charged with one or more misdemeanor offenses. These cases have now been accused and filed with the State Court of Fulton County. This would be the defendant's initial appearance before a judicial officer, at which time he or she will be informed of your new accusation number, the charges brought against him or her, who is going to be their appointed counsel if necessary, and also to set a bond. If you are a defendant charged with a misdemeanor offense, please remember that you have a right to remain silent. Anything that you choose to say in open court, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. All right, courtroom 2, let's begin. Who do we have first? And let me see, Miss.
We have position number 11, Peyton. Miss Peyton.
Okay, and who do I have? Miss
Champion as the
Miss
litigation
Champion.
manager.
Okay, I'm sorry, I was looking for Miss Champion. The reset date is
It's gonna be July 11th.
July 11. Thank you. All right, we have Asia Payton, a middle name Imari, case number 24CR 3974J. Miss Amari is, excuse me, Miss Payton is accused of battery, family violence with regards to a Maurice Parks from June 19th, 2024. Miss Payton, you've been advised of your right to remain silent, and your attorney is Miss
Thank
Kim.
you.
All right.
Thank you.
Mhm. Any priors, Miss Washington?
Yes, Your Honor, this is the defendant's second arrest. The last arrest and the first arrest was April 6, 2015 for possession of marijuana less than an ounce. The defendant meets the criteria for UJR. Nothing
All right.
further.
Thank you. Miss Mokeke, good afternoon.
Good afternoon, Your Honor. Officers responded to the incident location in response to a dispute call. Upon arrival, they spoke with the defendant, who stated that her and her partner, Maurice Parks, had gotten into a dispute. The defendant advised that she called the police because she wanted Mr. Parks removed from the residence. The defendant advised that Mr. Parks had been living there for about 3 months, and the parties were having a disagreement. When the defendant took the victim's phone, the victim grabbed her from behind and wrestled her to the ground as he tried to get his phone back, at which time the defendant bit him. The victim did have a bite mark on his person and also showed police a video where the defendant was yelling in his face and was throwing a bag of clothes at him. Based on the evidence, officers deduced that the defendant was the primary aggressor. Our office has had a chance to speak with the victim, Mr. Parks, who stated that he had been staying with the defendant since March, but he has since left the residence. He did confirm the events in the warrant, stated that the defendant has vandalized his property in the past, but this is the first time she has been violent towards him. And he did tell our office that he wants no contact with the defendant. The
All right.
state's recommendation is a signature bond through pretrial services, no further contact with the victim, anger awareness, and no drugs, weapons, or alcohol. And at this time, I would ask the court to sound for Mr. Parks.
Mr. Maurice Parks, if you're on Zoom, please unmute and start your video. All right, Ms. Kim, I'm going to set a $2,000 signature bond through pretrial services, level 1. She can return to the property at 250 something Main Street in Atlanta, Georgia. She's to have no further contact with Maurice Parks, no illegal drugs, no alcohol, no weapons, no firearms. And she would need to attend and complete 2 anger awareness classes with pretrial services.
No objection, Your Honor.
All right, maybe a brush up on dispossessory law.
Sure.
Okay, thank you. Next case, please.
Position number 15, Miss Amani Walker.
And who represents Ms. Walker? This is a cross-defendant with, cross-defendant with someone. I can't remember who it was.
Miss McLeod.
Good evening, Your Honor. I represent Miss Walker.
Okay. And I remember it was a cross-defendant. I can't remember. I'm sorry, Ms. Walker. Was it Mr.
Dominique Harris, I believe, is the cross-defendant.
Was that case on the calendar? Yes, position 7. That's what it was. Is Mr. Harris in the courtroom?
Yes, Your Honor.
Okay, may he stand behind her, please? And who represents Mr. Harris?
I do.
Ms. Atay? Okay, thank you. On position 7, I have case 24 CR 3970D, State versus Dominic Harris, accused of simple battery family violence with regards to cross-defendant Amani Walker. Incident date appears to be June 19th, 2024. Mr. Harris, you've been advised of your right to remain silent, and your attorney is Ms. Hoda Atay. Ms. Walker, your case is 24 CR 3978D, in which you're accused of battery family violence from also June 19th, 2024. You have been advised of your right to remain silent, and your attorney is Ms. Maureen McLeod. With regards to both cases, it appears to be they are both occupants of the same premises, and you both, may I, Ms. Washington, may I have Mr. Walker's GCIC, Mr. Harris, excuse me, Dominic Harris's GCIC?
Yes, Your Honor, this is his second arrest. The last arrest was November 7th of 2022 for transfer property subject to a security interest, which the defendant does appear to be serving 12 months on probation. And the sentence date is August 31st, 2023. The defendant meets the criteria for level 1.
All right. And what about Ms. Walker?
This is Ms. Walker's 5th arrest. The last arrest was June 4th, 2014 for 2 counts of simple assault. There's a 2011 arrest for terroristic threat. No disposition was listed. There's a 2014 arrest for willful obstruction, enticing, and a CWAG charge, and that was out of Haralson County, which appeared to be dismissed. That defendant did meet the criteria for UJR. Nothing further.
Thank you. Ms. McKechnie, we can begin with Amani Walker.
Okay, there we go. Officers arrived at the incident location where they met with defendant Harris, who stated that him and defendant Walker were arguing over their home conditions. Per defendant Harris, he had been living in the home for about a week and had given his girlfriend Shakira Calloway rent money. I believe Ms. Calloway also resides in the residence. Defendant Harris advised that defendant Walker was putting his property outside the home when a verbal altercation occurred. The two parties began bumping into each other until defendant Harris pushed defendant Walker out of his personal space. At this time, defendant Walker punched him and the two began fighting. Defendant Walker states that defendant Harris punched her first, and defendant Harris did sustain bruises and scratches on his arms, and defendant Walker did not appear to have any marks on her from the altercation. For defendant Amani Walker, the state's recommendation is a $2,000 surety bond, no further contact with defendant Harris, anger awareness, no drugs, weapons, or alcohol while out on bond.
And what about Mr. Harris?
For Mr. Harris,
Yeah, what's the recommendation?
recommendation is a signature bond through pretrial services, no further contact with defendant Walker, stay away from the incident location as he had been residing there for only a week, anger awareness, no drugs, weapons, or alcohol while out on bond.
All right, thank you. Ms. McLeod, what's your argument on just stay away, no contact?
We are fine with him staying away from the residence, Your Honor. There's absolutely no relationship between my client and himself. This is the house where she has lived for some time. And I believe his girlfriend was living there and a child.
Does she own or rent? Is that a mortgage or a lease?
It's a lease, Your Honor, but my client and her significant other are the ones who are on this lease, and they allowed his girlfriend and her child to stay there for a little while because they didn't have anywhere to stay. My client said that there was an issue because one of the toilets was backed up and she was trying to fix it because there was water everywhere and a mess. And she decided that she would fix it, and she was just trying to do that when the cross-defendant interfered and attacked her, Your Honor. I would ask the signature bond for my client, and as I said, the state is requesting that he stay away. We're fine with that. There's no reason why my client should have any contact with him because she has no particular relationship with him at all.
Ms. Atay, any comment about stay away, no contact?
Your Honor, his family has already moved out, so we're fine with stay away and no further contact.
When you say family, who do you mean?
His girlfriend, as stated in the warrant, she lives there with the
Right.
child, and he had just recently moved in, but he's fine with the stay away and no further contact.
Right, so those the only two people, right? Miss Calloway, I think that was her name, and Mr. Harris. Would that be correct?
And also two children, a 2-year-old and a 1-year-old.
Who belong to Harris and Calloway?
Yes.
Okay. Mr. Harris and Ms. Walker, each of you will receive a 2,500 signature bond through pretrial services, level 1. You are both to have no contact with each other. So with Mr. Harris, no further contact with Amani Walker from today onwards. And you're to stay away from the location in question, which is the Neron Street, 2789 Neron Court in Atlanta, Georgia. No illegal drugs, no alcohol, no weapons, and no firearms. And you report to pretrial once a month. Ms. Walker, same issue. You have no contact with Dominic Harris after today. You report to pretrial once a month, and you are to also not consume any illegal drugs, no alcohol, and not own or possess any weapons and firearms. Now, Mr. Harris, as you have vacated the premises, you are required by court order to give us a valid mailing address in writing with the clerk's office within 30 days from today. Both of you have an active, open criminal case, and you are both required to report to court when summoned. If you both fail, either one of you fail to appear, a bench warrant will be issued for your arrest. So make sure that both of you have a current mailing address with the court at all times. And both of you might want to read up about dispossessory law. If you all decide to take in people to live in your place, you need to understand the rights of a landlord and a tenant, or a sub landlord. Okay, thank you.
Thank you, Your Honor. That concludes my business before the court today. May I be excused?
Yes, have a good day. Thank you.
Thank you. You're welcome.
Next, we can go to position number 5, Freeman.
This is State versus Jessica Freeman, and accused of interference with custody, 24 CR 3967G. Appears to be based on a private warrant and alleging interference on November 26, 2023. Ms. Freeman, you've been advised of your right to remain silent, and your attorney is going to be Mr. Cook. All right, thank you. All right, and Ms. Washington, anything prior to November 26th?
Your Honor, the defendant has 13 arrests. This is the 13th arrest. The last arrest was December 26th of 2021 for disorderly conduct. There was an arrest in 2017 for trafficking a person, contributing to unruliness, and interference with custody, which appeared to be dismissed, and that was out of Fulton County. The case number is 17CP 170718. And there is also a 2022 misdemeanor conviction for willful obstruction, 2 FTAs in 2013, and meets the criteria for level 3. Nothing further.
All right, thank you. Ms. Falk, good afternoon.
Yes, sure. Good afternoon, Your Honor. This incident happened, you're correct, it was a private warrant, and this incident happened November 25th, 2023. The defendant, who does not have custody of the minor child, KF, took KF from Anitra Freeman, who is the legal custodian, for 3 days and refused to return the child. The child, KF, was eventually found on November 27th, 2023 in DFAC's custody. We did have an opportunity to speak with Anitra Freeman, who stated she will be on the Zoom today. She stated that she's the mother of the defendant and the grandmother to KF. She stated she has had KF since he was 5 days old. She also stated that the defendant has never had custody of KF, and he is now 11 years of age. She furthermore stated that she had come to Atlanta to make funeral arrangements for her sister when she let the victim go to the movies with some family members. When the family members returned, KF was not with them. When she asked where he was, she was told that the defendant came and took him. She stated she tried calling the defendant to meet with her so that she could retrieve KF. The defendant refused, would not answer the phone, and eventually the defendant took KF to the hospital and reported that he was being abused by Miss Freeman, which is how KF ended up in DFAC's custody. According to Miss Freeman, KF was checked out. She was able to show them guardianship paperwork, and KF was released to her. She stated that KF is terrified of the defendant. They do not want any contact with her. And as I stated, she is here on the Zoom. We are asking for given the history, the failures to appear and charges, though that they were later dismissed, involving trafficking, contributing to the unruliness of a minor, and interference with custody. We do have serious concerns about the fact that she came and took this child from the legal guardian's care without notifying the legal guardian, and the child was missing for 3 days, which I can only imagine must have been a terrifying experience for Miss Anitra Freeman. Therefore, we are asking for a $5,000 surety bond. We're asking that there be no contact whatsoever with KF and Anitra Freeman, that she must stay at least 200 yards away from them, no alcohol, drugs, or weapons. That's all for the state. And again, we would like to sound for Mr. Anitra Freeman.
Ms. Freeman, if you'd like to contribute to the proceedings, you need to unmute and start your video.
Hello. Hello, Your Honor. Can you all see me?
No.
Hello?
Please start your video.
It's stating that the host added you.
Mr. Jordan, could you prompt Ms. Freeman to start a video, please?
Okay, can you see me, Your Honor? Hello, can you see me?
Yes, now I can.
Okay, I'm sorry. I apologize. Your Honor, I'm okay with what the state has said. The child is terrified.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do, yes, ma'am.
Since the child was recovered from defects in November of 2023, has Ms. Freeman attempted any more contact with KF?
She came to a residence where we were staying in Madison, Georgia, brought the police there. I was up in Atlanta at my residence, and I have a house.
No, listen very carefully.
Yes, ma'am.
Since the child has been recovered from defects,
yes,
after she allegedly took him, have there been any more visitations since then?
No, ma'am, there have not been any visitation, but she has come, and I've had to call the police several times since this incident.
Okay, thank you. You may mute your screen. Thank you. Okay. Mr. Cook, it appears that your client wants to say something. She has a right to remain silent. Anything she chooses to say can and will be used against her. You please unmute, Mr. Cook. Ms. Freeman, excuse me, Miss.
They're both Miss. They're both.
Yeah, they're both Miss Jessica Freeman. Please put your hand down. I will address you shortly. Thank you.
May I inquire of Anitra Freeman just briefly?
You may. Ms. Anitra Freeman, please unmute.
Yes, ma'am, I'm unmuted.
Ms. Freeman, in the custody order you have, is there a provision for visitation by Jessica?
Ms. Anitra Freeman, please unmute.
No, sir, there's not. Can you hear me? I'm sorry. I apologize. I thought it was unmute, but no, sir, there's not. It's the answer to the question.
And was that proceeding, the custody proceeding, was that in Fulton County?
Yes, sir. It's in Fulton County Juvenile Court. The order right here is dated October the 18th, 2012, when the child was, the year the child was born.
Okay. Thank you. That's further.
All right. Courtroom 2, please unmute. Ms. Jessica Freeman, if you wish to contribute to these proceedings, please remember that this is an open, active case against you, and anything you choose to say can be used against you in the treatment of your case and can make it very difficult for your lawyer to represent you. So if you want to dispute what the allegations are or what Miss Anitra Freeman has said, you may end up incriminating yourself.
Okay.
So do you want to say something, or would you like to would you like to exercise your right to remain silent?
I would like to speak.
Go ahead.
Okay, so back, that trafficking charge and the interference with custody, all of those were charges she put on me, and they were dismissed.
Yep, I agree with you. They were dismissed.
Because she lied. So she, if you look in your system for Fulton County, she have had men locked up for rape and sodomy, lies, going down there and putting false charges.
Right now, the only question we have to address
I'm
is
saying is-
only, no.
This is a lie. That's all I'm saying. And I'm away from
Okay.
my other children. We're having a custody battle right now.
Okay.
And I have court on July 11th. So if she get a stay away order for me, that's gonna put me away from my son. That's what she's trying to get. And she just lying right now. I haven't been around this lady.
Miss Jessica Freeman, I am not going to allow you to start calling people names on Zoom. What I want from you is whether there's been a modification of any custody order. Has there been a modification?
Yes, we have court on July 11th.
Okay, so there is a court hearing for a modification, but there has not been a modification. Would
It's
that be
for
correct?
return of custody. Yes.
Okay, all right. But currently there's no modification. Is that correct?
We have what she said on Zoom is a lie about no visitation, all of that. That's a lie. Now she's lying.
Now, I've already read the warrant and it appears to be no unsupervised visitation. That's what the allegation is.
I have proof in my cell phone that I picked up Cody from her residence, and they're gonna be very upset with her about coming to file charges.
That is not the question I asked. All I'm saying is that the warrant claims that the order says no unsupervised visitation.
Well,
Has that been amended?
No,
Okay.
I've been getting him by myself. I've been getting him.
All right, thank you. Bond is set. Anything else, Mr. Cook?
No, Your Honor, this is a difficult one. I do think there's been some game playing and some private warrants without merit, but I don't have enough at this point in the background to go any further. And I know we're just talking about bond. I certainly think stay away, no further contact, except that which might need be made in court hearings, and I don't know that there'd even be a need to have contact with a child.
Okay.
And so I'd be looking for a signature bond and stay away, no further contact.
Miss Jessica Freeman, the bond I'm going to set is going to require you to comply with certain conditions. If you violate any of these conditions, you will be back in jail with a tremendously high bond. Your bond is going to be set at $25,000. It's going to be a signature bond through pretrial services level 3, which means you report to pretrial services once a week. We must have a good current mailing address on you at all times. You are to have no further contact with Anitra Freeman and no further contact with the minor referred to as KF until further order of the court. So that visitation or that unsupervised visitation or any kind of joint custody, you're not allowed to have any contact with the minor child referred to as KF until there is a further order of the court. So if there's a court hearing coming up in July, y'all can challenge the custody or anything, and that judge can thus have the authority to amend the no further contact. But right now, if you don't understand this, I'm explaining to you as clear as possible. You cannot have any visitation. You cannot have any unsupervised visitation. You cannot call. You cannot speak. You cannot try to be anywhere near Anitra Freeman and KF. Do you understand? Okay. If you violate this bond, if you get arrested again for anything else, if you don't report to pretrial services once a week, or if you don't show up in court when summoned, the $25,000 signature bond will be converted to a surety bond or a cash bond, depending on the nature of the non-compliance. No illegal drugs, no alcohol, and no weapons. Thank you.
Maybe next we can go to position number 8, Ms. Harris.
Ms. Harris? Okay. You're talking about Eugenia Harris?
Yes, ma'am.
Okay. This is case 24 CR 3971E. Ms. Harris is accused of battery family violence with regards to Gregory Allen, allegedly on June 19th, 2024. Is Gregory Allen also a cross defendant? No? Okay. Ms. Harris, you've been advised of your right to remain silent, and your attorney is Ms. Atay. All right. I've got a indication there was a dual arrest with Gregory Allen. Is Mr. Allen accused of a misdemeanor offense? Ms. Mukaki?
I will have to check. I do see that he was also arrested, but I will have to double check to see if he is still in custody.
All right. Well, if he's not in custody, then I'm going to assume that the public defender's office is properly representing Ms. Harris. She's not conflicted out. Would that be correct, Ms. Atay?
That's correct, Your Honor. And I didn't see Gregory Allen on the pull sheet, but my client states that he is here and she's spoken with him. So maybe he should have been on the pull sheet and he wasn't, but he's here.
All right. Well, I guess.
And he would be more.
But he's not on the pull sheet. So if he's going to be on another calendar, then that would have to be conflicted out.
So it looks like he was booked at 11 a.m. and he's going to be on tomorrow's SEA calendar.
Well, okay, that's how it'll work out then. In the meantime, Ms. Washington, any priors on Ms. Harris?
Yes, Your Honor, this is the defendant's 5th arrest with multi-state interaction in Illinois and Indiana. The last arrest was November 25th of 2003.
That's not me. That's not me.
All right. What's Miss Eugenia Harris's the date of birth?
For one, you know. When?
What do you, I have May 11th, 1965.
Yes. Where did you get 5 arrests?
All right, May 11th, 1965, and is that the GCIC? You may continue then.
Yes, I have a clean record. She said it was 20 years ago.
Miss Harris, can we just let Miss Washington finish reading this criminal history record, and then your attorney can contest it, all right? Thank you.
Yes, Your Honor. This is the 5th arrest with multi-state interaction in Illinois and Indiana. The last arrest that I have listed was November 25th, 2003 for criminal trespass and disorderly conduct, a 1990 conviction for 2 counts of battery, and that was out of Illinois. The defendant does meet the criteria for level 1. Nothing further.
Thank you. Ms. McKechnie, do you have a recommendation for Ms. Harris?
Yes, Your Honor. The state's recommendation is a $2,000 surety bond, no further contact with the victim, Gregory Allen, stay away from the incident location, and no drugs, weapons, or alcohol. The defendant is accused of attacking the victim along her and her grandchildren are accused of attacking the victim. The victim did have scratches and bruises to his chest and leg.
I'm sorry, Ms. McKechnie, that's either background noise coming from your location or from the jail. I'm not sure. Mr. Tay, could you mute the screen? Maybe that might help. Thank you. Please continue, Ms. McKechnie.
Yes, Your Honor. As I was stating, the defendant and her grandchildren are accused of attacking the victim. The victim had scratches and bruises to his chest area. And the defendant told officers that her and the victim were roommates, and the victim became upset when Her granddaughter pushed his dog and ate the food that the victim had bought. The defendant further claimed the victim pushed her to the ground, kicked her, and began throwing objects and destroying the home. However, officers did not see any injuries on the defendant, and witnesses on the scene stated that all the parties were fighting each other. And again, the state's recommendation is a $2,000 surety bond, no further contact with the victim, stay away from the incident location, and no drugs, weapons, or alcohol.
Ms. Tate? I'm sorry, yes.
My client is 59 years old. Any history that you heard, and she states that the 1990 is not her. She states, well, the 2003 criminal trespass, it's 21 years ago. It's her last arrest. She has lived in Georgia for almost 5 years. She has raised 4 children and helps care for 11 grandchildren. This is her home, Your Honor. I would object to a stay away. She states that her and Mr. Allen have had contact while they've been here. And she wants no violent contact with him. But I guess we can't hear from him now, so no further contact is fine, but I would ask for her to be able to return to the home. She does live there and cares for several of her grandchildren on a daily basis. She is disabled. She has 2 autoimmune conditions and also has neuropathy in her foot, and which makes it difficult for her to walk. And in general, she's in very poor health. She states that neither one of them called the police. The neighbors called and gave incorrect statements. And she denies that there was anything physical that happened at all. She states that it was nothing physical. So I think a $2,000 good bond in this case is ridiculous. I would ask for a signature bond through the jail. And again, no stay away. And I request no violent contact with the complaining witness who was also arrested.
Okay, thank you. The bond is set at 2,500 signature bond through pretrial level 1. No further contact with Gregory Allen. So from this point onwards, she's not to communicate or have any contact with him. She may return to I think it was the Hardwick Street location. She may return to that location. But as I've got the no further contact with Mr. Allen, he will not be allowed. So Ms. Mokeke, whoever is the prosecutor tomorrow, or whenever we address Mr. Allen, he has to stay away from the Hardwick Street location and update the court with his new mailing address. He's allowed a one-time visit. She is to report to pretrial once a month. She's to undergo 2 anger awareness classes through pretrial services. No consumption of illegal drugs, no alcohol, and no possession of any weapons and any firearms. Ms. Harris, after today, Mr. Allen is not allowed to live with you at that property, and he's to have no contact with you. If you encourage him to come back to the house and have contact with you, that will simply require that both of you be arrested again and be brought back to jail. Your next court date will be sent to your Hardwick Street location. Thank you. Next case, please.
We go to position number 2, Mr. Duffy.
Come on.
Is this Thaddeus Duffy?
Yes, ma'am.
Okay.
Your Honor. Thank you.
This is State versus Thaddeus Duffy, case 24 CR 3966J, accused of criminal trespass, loitering, and prowling, allegedly occurring on June 19th, 2024. Mr. Duffy, you've been advised of your right to remain silent, and your attorney is Mr. Cook. Is that correct? Okay. Any priors, Ms. Washington?
Yes, this is the defendant's second arrest. The last and first arrest was December 11th, 2022 for criminal trespass. The defendant does meet the criteria for level 1. Nothing further.
No. Ms. Falk?
Yes, Your Honor. This incident happened June 19th, 2024 at 504 Hopkins Street Southwest in Atlanta. Miss Tamara Jones received a notification at around 1:56 a.m. on her Ring doorbell camera that somebody was standing outside the door of her home. Miss Jones then observed the defendant on her porch attempting to open the door of her home before leaving. Mike, who is a neighbor, stated he saw the incident and approached the defendant. When Mike asked the defendant what his business was at 1:56 in the morning outside of this woman's house, the defendant stated to Mike that he was here for her. Knowing that Miss Jones was alone with her 12-year-old son in the home that night, the neighbor became very concerned, followed the defendant. Michael Finley corroborated this incident. I will state that we did have an opportunity to speak with Miss Tamara Jones. She stated she does not know this defendant. She was in her home at the time of this incident and witnessed all of this on her Ring doorbell. And it was clear to her that the defendant was trying to open her door and make entry into her home. She states she wants no contact with this defendant, wants him to stay away from her residence. And we would like to sound for her at the completion of our recitation of facts. We are asking for a $1,000 surety bond, $500 per count, no further contact with Tamara Jones, stay away from the 500 block of Hopkins Street Southwest in Atlanta, no alcohol, drugs, or weapons. We do have some MH concerns, and we are asking for an MHET based upon that. Simply put, the time of his going to that house in the middle of the night, trying to get into her home while she was there with her child, and his very cryptic and quite frankly, a little creepy statement to Mike, the neighbor, does give us some cause for concern. And that's why we're asking for the MHET and the surety bond. That's all for the state. We would like to sound for Miss Tamara Jones, Tamerra.
I do see Miss Jones on the Zoom session, but if she'd like to unmute and start a video, she can contribute to the proceedings.
I am not sure if Ms. Jones is going to unmute. However, this is Toretta Jones, her personal attorney. She is requesting that there is a stay away put in place for her minor son, and her home.
Okay. Miss Attorney Jones, does your client have any kind of familial or?
She does not know this man at all, has never seen him, and is very concerned.
Understood. Thank you.
Mhm.
Mr. Cook?
Yes, Your Honor, we have no objection to a stay away and no further contact. Given the accused background, we would be seeking a signature bond at whatever level the court deems appropriate.
All right.
And Your Honor, may I make an inquiry with Miss Toretta Jones, please?
Yes.
Miss Jones, can you just give me the initials of the minor child? Please do not say the child's name.
KK.
Okay.
And I
Great.
will contact you after this. if
That
you
is
have any
fine.
Additional
Thank you.
information. Mhm.
Anything else? No?
That's
Okay.
all, Your Honor.
On the criminal trespass, that's going to be a $500 surety. On the loitering and prowling, it's going to be a $1,500 surety. The total bond is a $2,000 surety bond. Next court date is June. No, it was, I'm sorry, Ms. Champion, I forgot to write it down.
It was July
July
11th, John.
July 11th. Okay. Next court date is July 11th at 9 a.m. Mr. Duffy, under the circumstances of the case, given the allegations set forth in the warrant, I am setting a $2,000 surety bond. Once you make bond, please be sure that you stay 500 yards away. That's the length of 5 football fields from 504 Hopkins Street in Southwest Atlanta. You're also to have no further contact with Tamara Jones and her minor KK. You have to stay 200 yards away from both these individuals, not have any form of communication, whether it's in person, through a phone, computer, a computer device, or even on social media, and even through third parties. We'll see you at your next court date on July 11th. Thank you.
And Your Honor, regarding the MHET?
I saw that on the warrant, but until the defense wants to have him reviewed by a social worker, I'm going to delay that order. I have no indication otherwise that.
Can this, yes, Your Honor, but can the state request that as part of the order, he be interviewed by a social worker?
Sure.
Thank
Mr. Cook, can you please reach out to the social worker and indicate that as a condition of the bond, he needs to be interviewed?
Yes.
All right, thank you. So, Ms. Champion, please make a note that he's to be interviewed by a social worker before the next SAP date. Next case, please.
Next, we go to position number 14, Mr. Scruggs.
This is State versus Willie Scruggs, case number 24 CR 3977Y. Mr. Scruggs is accused of battery, family violence. The alleged incident date is February 2nd, 2024. Mr. Scruggs, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kim. Any priors, Ms. Washington?
Yes, Your Honor. This is a defendant's 19th arrest. The last arrest was June 9th of 2011 for a probation violation. There are 3 felony convictions outside of the 10-year period, 3 misdemeanor convictions outside of the 10-year period, a 94 misdemeanor conviction for I believe aggravated stalking. The defendant was also, simple assault. The defendant was also arrested on simple battery and battery, but those charges were dismissed. There's a 97 arrest for simple battery, but no disposition listed. A 2008 arrest for cruelty third and simple battery family violence, and that was out of Fulton County. The case number is 08CR332286. The defendant does meet the criteria for level 3, nothing further.
Ms. McKay?
Yes, Your Honor. And I would also like to point out he has a 1985 CWAC conviction, it looks like, where the disposition says confinement 20 years. In this particular incident, the victim, Deborah Scruggs, stated that her and the defendant had been separated for about 2 weeks when she returned home from work to find her apartment door unlocked. When she entered the apartment, she was startled by the defendant, who then lunged at her and punched her in the face, which caused her to fall. As she was on the ground, the defendant stomped his foot on her chest and then fled the scene. The victim did sustain swelling to her face and our office has had a chance to speak with the victim, Ms. Scruggs, who did confirm that her and the defendant are married and do not live together. She also confirmed the events in the warrant and stated that they had an altercation in the past where the police were involved, but that was 15 years ago. And that was the 2008 simple assault and cruelty to children that the time had expired on. The victim stated that they have not had any recent altercations and they have had contact since the incident and there has been no violence. She stated she's not in fear of the defendant and is okay with contact. She is okay with the defendant coming to her residence. However, given the defendant's history and the fact that they have had an incident where police were involved and do appear to have a domestic violence history, the state is recommending a $3,000 surety bond, stay away from the incident location, no further contact with the victim, Deborah Scruggs, no drugs, weapons, or alcohol while out on bond. And at this time, I would ask the court to sound for the victim in this case, Ms. Scruggs.
Ms. Scruggs, did you want to contribute to the proceedings? You can unmute your screen. Did you want to say something?
Hello, I just wanted to just say that we do have a 15-year-old daughter.
Okay, in that case, please raise your right hand.
Okay.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Okay. Yes, I do see in the warrant that you both you and the defendant share a teenage child. Is there anything else you'd like to tell us about contact or whether he's staying with you or something to that effect?
No, we don't live in the same residence. No.
Okay. And what about contact with him?
I don't have any problem with contact. I'm not afraid, and I don't have any problems with contact with Mr. Scruggs.
But you don't want him living in the same property. Is that correct?
Well, that's correct.
Okay. All right. Thank you. Ms. Kim?
Yes, Your Honor, my client, Mr. Scruggs, is 62 years old. He was born and raised here in Georgia. He strongly prefers to have a no further violent contact. However, he has no objection to no further contact and stay away. As long as he has a third-party transfer for his 15 years old minor. He actually has an associate degree, and indeed he turned himself in to take care of this matter. He's not afraid of, he wants to be responsible. However, he does not think this was what his wife actually wanted at all. We would like to request for a signature on bond through pretrial level 1. Thank you.
Okay. Bond is set at 3,000. It's going to be a signature bond through pretrial services. And this is going to be a level 2 reporting. No further violent contact with Deborah Scruggs, but he must stay 200 yards away from the incident location, which is 400 Fairburn Road, Unit 164 in Atlanta, Georgia. He's not allowed to be anywhere near that location. No illegal drugs, no alcohol, no weapons, and no firearms. Given his prior felony convictions, he's not allowed to own or possess any firearms. While he's out on a signature bond, he will report to pretrial twice a month, and within 30 days of being released, he will enroll in what we call a domestic violence intervention program. He will show proof of enrollment in such a program by his 3rd visit with pretrial services, and he will continue with those classes until he obtains the necessary certificate, which he will show proof to his pretrial officer. This is a requirement of bond. It's not a question of guilt or innocence. And Mr. Scruggs, if you and Mrs. Scruggs would like to share in the visitation of the minor child in question, then this is something that you can communicate with Ms. Scruggs. Ms. Scruggs, you and Mr. Scruggs can communicate with each other with regards to visitation of the minor child in question, the daughter that you share. But that's something that I'm going to leave entirely up to you, Mrs. Scruggs, to decide how that would move forward.
Okay, yes, ma'am. Thank you.
All right, thank you. Mr. Scruggs, within 30 days from being released, you will update the court with your current and accurate mailing address. It cannot be the Fairburn Road location, and we will send you your notices to come back to court when summoned. So please be sure that we have your current mailing address. Thank you. Next case, please.
Petition number 6, Christopher Grant.
This is State versus Christopher Grant, accused of battery, family violence, and 1 count of battery. So it's 2 separate charges. Case number 24 CR 3968E. Incident date apparently is from June 19th, 2024. Mr. Grant, you have been advised of your right to remain silent, and your attorney is Ms. Atay. Any priors, please?
Yes, Your Honor, this is the defendant's 2nd arrest. The last arrest and the first arrest was May 31st, 2024 for aggravated assault out of East Point, which does appear to be an open case here in Fulton County. The case number is 24 PI 003-928. The defendant meets the criteria for level 2. Nothing further.
Okay, thank you. Ms. Falk?
Pretrial, can you repeat the case number on the open aggravated assault again, please?
Yes, it's 24 PI 003-928.
Thank you. I appreciate it. Your Honor, this incident happened June 19th of 2024 at 6100 North Cut Road in Fairburn. Miss Patisa Fields stated that her son, the defendant, asked her for the title to his vehicle. Miss Fields stated she did not have the title to the vehicle, which was parked on her land. The defendant then became aggressive with her, began yelling and cursing at her. Her her younger son and the defendant's younger brother, which is Timothy Galden, then got involved and tried to get between the two of them due to the behavior of the defendant. He got in between Miss Fields and the defendant. The defendant then headbutted Mr. Galden and a physical altercation began. The officers observed that Mr. Galden had open wounds to his eye and his cheek. We did have an opportunity to speak with Patisa Fields, P-A-T-I-S-A Fields, and Timothy Galden, which is G-A-U-L-D-E-N. Mr. Galden stated he is the victim and brother of the defendant, and they all live together at the incident location. He did confirm the events in the warrant. He also stated that this has been ongoing with the defendant being violent, both toward him and Miss Fields. Miss Fields did state she believes the defendant needs an MH evaluation because he is becoming more violent. She stated she is in fear of the defendant, and she is also concerned for her son, Timothy Galden's safety. The request is for no contact with the defendant and for him to stay away from the residence at 6100 Northcutt Road in Fairburn. Miss Fields should be on the Zoom, and we would like to sound for her. The previous arrest for aggravated assault, which was less than a month before this incident, the defendant did receive a $5,000 surety bond as well as a stay away order. The individual in that case is not the same as either one of these victims. We are asking in this case for a $3,000 surety bond, no further contact with Timothy Galden and Patisa Fields, and MHET, no alcohol, drugs, or weapons, and stay away from 6100 Northcutt Road in Fairburn. We would at this time like to sound for Miss Patisa Fields and Mr. Timothy Galden.
Ms. Fields, if you'd like to contribute to the proceeding, you would need to unmute and start your video. You don't have to say anything if you don't want to.
Yes, ma'am. This is Mrs. Fields and Timothy Galden. We're here. Can you hear me?
You need to start your video, please, and unmute your screen. Mr. Jordan.
I'm working on trying to unstart. Can you guys see me now?
No. Mr. Jordan, could we prompt the user to start their video, please?
Yeah, when the altercation happened, he broke the screen.
Ma'am, I need your video on.
I know, I'm trying to get it on, but my phone is broke.
Well, then that's a problem.
Post has to ask you to start the video. Okay, ma'am, do you see me now?
Yes, I do. Yeah. Now lower the device so we can see your face. Raise it up and put it in front of your face. Okay. Raise your right hand, please. Other right hand. Oh, you got it holding. All right. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Are you in a moving vehicle?
Yes, ma'am.
Who's driving?
My nephew.
All right. Only you can testify then too. Or what would you like to tell us?
That Christopher Grant does not stay there, and my son is right here. He said he did not tell the lady that. And
I don't know what you mean. What do you mean does not stay there?
Christopher Grant came from college and just decided to drop out of school. Christopher Grant has been causing problems and fighting in college. He said he was going to transfer colleges to down here. He stays in East Point, Georgia, on his driver's license. Besides all of that, Christopher Grant has been very violent to a lot of situations and a lot of people. I am the one that helped him out of the first.
Hang on. Miss Fields, do you live at that incident location?
No, I live with my brother at 553.
I don't want to know where you live. I'm asking you, do you live at the incident location?
No, ma'am, that is my property, my land.
And does Timothy Galden live at the incident location?
No, ma'am.
Okay.
That's just my land. That's a piece of property I have.
Understood. And, but you have your own housing, correct?
Yes, ma'am.
All right.
Correct.
Okay, anything else? I really don't want to hear his propensity for violence or lack of it. I just want to know whether
Okay.
you and Mr. Golden share the same house with him.
No, ma'am, we
All
do
right.
not. And
Have
I
you,
don't
have
want to stay
you,
around.
have you any reason to go back to that location in the next few months?
Yes, that's my property. I go back
Again,
every day.
you don't live there, but other than that, do you have any other reason to go back to that property? Do you have personal belongings? Do you have tenants there? Is that a working property? Do you have any other reason to go there?
Yes, I
What?
do.
What's the reason?
To maintain my property, cut the grass, work on things that I'm working on out there, finishing the project I have going
All
on
right,
out
Ms.
there.
Fields, if you want to remove Christopher Grant from that property because you are the alleged homeowner or the title owner, you need to consult with an attorney and file a dispossessory action. Do you understand?
Ma'am, he doesn't stay there. He just got
Miss
out of jail.
Fields,
And the
Miss
address.
Fields, Miss
Yes, ma'am.
Fields,
Yes, ma'am.
that is the order of the court. Thank you. Now, Mr. Tay, what is your take on this case?
Your Honor, my client is 21 years old. He's young. He is a junior at Bethune-Cookman University in Daytona, Florida. He was there on a football scholarship. From what he tells me, he hasn't dropped out. He's majoring in biology, but he was hoping to transfer to West Georgia and complete his last year of college and play football there. Of course, that recent case from a month ago, it's open, so he's presumed to be innocent of those charges, and he does deny those allegations in that case and states that he actually has PTSD from that altercation where he was acting in self-defense. It was a stranger, so nothing like this at all, a battery, family violence. He does deny the allegations here. Even the warrant.
I'm sorry, are you talking about Curtis Bankston? The alleged victim in the aggravated assault case?
No, I'm talking about my client.
No, you said that was an alleged stranger.
To me.
Yes, he doesn't know. I mean, what I'm saying is it's not family violence.
Okay, that part I do get.
Okay. Your Honor, as I said, he is a full-time college student, but home for the summer. He is working a summer job at a moving company, 2 men and a truck. In this case, the warrant reflects that his brother, became involved. He does state that his brother was the first aggressor. And this is only his second arrest. He doesn't object to the no further contact and a stay away, but he would like to, retrieve his car and the title to his car, which is at the property, I believe. I mean, I think it's hard to get any answer out of the complaining witness, and imagine how hard it would be to get a title to a car that you own from her.
Mr. Tay, let me ask you, are you saying that he doesn't want to return to the 6100 Northcutt location?
No, he doesn't live there. His car is there and the title to his car is there.
I'm going to ask you again, very simply. Is it your client's position that he does not live at 6100 Northcutt Road, Fairburn, Georgia, and he has no intentions of living there with the exception of retrieving his property from that location?
That's correct.
Okay, just want to be sure. Thank you.
A no further contact with his brother or his mother is fine. A stay away is fine. I would obviously object to the MHET, and I would ask in this case, it's only a second arrest. I would ask for a signature bond through pretrial services, even if it's at level 2, which is the recommendation of pretrial.
Okay. Well, he was already on a surety bond, and that didn't prevent him from getting into trouble again. I'm not saying he's guilty or innocent charge, but clearly, Mr. Grant does not understand that when you have an open felony case that can not only jeopardize your scholarship, jeopardize your ability to complete your future of what it was prior to the ag assault, that really gives me pause as to his ability to make judgments. On the battery family violence, the bond is going to be set at 10,000. On the battery, it's going to be set at 7,500. His total bond is going to be 17,500. It's going to be a signature bond through pretrial services level 3. Until he return, if he has to return to school to Florida or something to that effect, he needs to make sure that he gets a court order allowing him to amend his pretrial reporting requirements to telephonic. But until he gets such an order, he's required to report to pretrial once a week. He is to have no further contact with Patisa Fields. He's to have no further contact with Timothy Golden. He's to stay away from 6100 Northcutt Road in Fairburn, Georgia, in Fulton County. He is allowed a one-time visit to that location with a police officer to retrieve any personal belongings. If he believes that the vehicle is his, then, and he has the keys, he's able to drive back. Now, he is not to contact Miss Patisa Fields or Timothy Golden with respect to any alleged title to the vehicle. I'm sure if the title is in his name, he can obtain a duplicate title from the appropriate government agency. But he is not to contact any family member or any alleged owner of the car if he, any of the alleged victims of this case with regards to any the title. This is a second serious case involving violence. I'm going to require him to enroll in a DBIP as a condition to the bond. So within 30 days of being released, he will enroll in a qualified domestic violence intervention program. This is a 24-week program that he will need to undertake at his expense. He will attend all those classes diligently and present a certificate to his pretrial officer at the conclusion of the 24-week program. No illegal drugs, no alcohol consumption. He will be subject to random screens by pretrial for illegal drugs and or alcohol, and he's not allowed to own or possess any firearms. Within 30 days of being released, he will update the court with his current mailing address. As already indicated, it is not 6100 Northcutt Road in Fairburn, Georgia. So Miss Patisa Fields, she may return to the property, 6100 Northcutt Road at any time, since Mr. Christopher Grant has indicated that he does not live there. Any questions, Ms. Ate?
No questions.
All right.
Donna, can you repeat the bond amount?
It's 10,000 on the battery family violence and 7,500 on the battery. Total of 17,500 signature bond through pretrial level 3.
3,700, then they have a procedure.
I guess I thought it was one. That's why.
So she might as well
All right, Deputy, do you have it?
Yes.
All right, thank you.
You can go to position number 4, Mr. Fleming.
All right, Ms. Falk, if you want to ask victim advocate to contact Ms. Fields and advise her that the dispossessory requirement is not required, since I thought according to the warrant he was living there, but now he's not, so she's good to go.
Yes, Your Honor. Ms. Cheney is able to hear us and she will make contact with the victim.
Appreciate it. This is position number 4, L. Juwan Fleming, case 24 CR 3969F. Mr. Fleming has got 5 misdemeanor offenses stemming from a traffic incident from June 19th, 2024. The charges are fleeing, attempting to elude a police officer, misdemeanor possession of marijuana, failure to use a turn signal, willful obstruction of a law enforcement officer, and driving while license suspended or revoked. Mr. Fleming, you've been advised of your right to remain silent, and your attorney is Mr. Cook. Any priors, Ms. Washington?
Yes, this is the defendant's 16th arrest. The last arrest was December 22nd, 2023 for possession of a Schedule II controlled substance, purchase, possession, or sale of marijuana, driving while license suspended or revoked, and affixing materials that reduce or increase transmission or reflecting of a window. There's a 2012 arrest for driving while license without license valid and hit and run, a 2013 arrest for driving without a valid license and willful
Oh,
obstruction.
That's good. Thank you.
Okay.
Ms. Falk?
Oh, Your
what's-
Honor,
Yeah,
I do want to mention that there are 2 holds that I see. One in Conyers for trafficking cocaine case, and that warrant date was January 3rd, 2024. And then a second with Atlanta Police Department for an FTA, and that warrant date was February 21st, 2024.
all right. You know, I may have missed it. I didn't see the holes, but thank you for that. Ms. Falk?
Yes, Your Honor. This incident happened yesterday. And what occurred was the defendant was driving on Martin Luther King Boulevard, was trying to turn onto Hamilton E. Holmes, failed to use his turn signal. Officers Pearson and Sievers then attempted a traffic stop. The defendant was driving a 2015 Dodge Durango. He pulled into the CVS and then proceeded to flee at a high rate of speed. Stop sticks had to be deployed on MLK and Anderson Avenue in an attempt to stop the vehicle. The defendant did drive over the stop sticks, but continued driving. He continued on to I-20 West, tried to exit onto the Hamilton E. Holmes exit, but veered off into an embankment and crashed into several trees. The defendant then exited the vehicle and fled on foot from the police officers, but he was arrested hiding in the bushes approximately 50 feet from where the vehicle was abandoned. 2.3 grams of marijuana were found on his person. He claimed he fled. He did tell police he fled because of the suspended license and active warrants from Rockdale from trafficking and a warrant from City of Atlanta for FTA on a DUI case, both of which he's currently being held in jail on. Officers were also flagged down by construction workers who stated they saw several baggies being thrown out of the window at the intersection of Anderson Avenue and MLK Jr. Drive by the vehicle's occupants. Officers recovered a clear sandwich baggie with approximately 8.2 grams of an unknown bluish substance. Jan Gilliam, who's the second defendant in this case, who's currently in custody on felonies, was arrested. A handgun was recovered from the center console, which Gilliam stated was their gun. The state has, again, that 2019 conviction for fleeing and eluding and obstruction out of Harris County, 2019 conviction for obstruction in Fulton County. He's currently under first offender. Well, no, his first offender was sealed for an entering auto ×2 in Fulton County in 2021. He did have a 2021 probation violation out of DeKalb County, a 2022 theft by taking arrest. We're also showing a 23 CP 224463 case where he has a $10,000 surety bond, and a 21 case, which is 23 SC 189938 for aggravated assault strangulation. He's currently got a $15,000 surety bond on that case. We are requesting a $9,000 surety bond, $5,000 for the fleeing and eluding, $1,000 on the remaining charges. Absolutely no driving, no alcohol, drugs, or weapons, and no firearms. We also would ask that he have no further contact whatsoever with the co-defendant, which is Jan Gilliam, JANGILLIAM. That's all for the state.
Mr. Cook?
Yes, Your Honor. My client tells me he suffers from some severe spinal problems, and his left side is partially paralyzed. And so he's obviously not bedridden, but he has a lot of health problems. He's taking care of 3 children at home to the best of his ability, along with help from his mother. He has obviously a lot going on. So we would ask in this case, we have no problem with any of the conditions of bond, but we would ask, given the other things he has going on, that he would have to take care of, that he gets a signature bond at whatever level the court deems appropriate in this case.
Understood. Thank you. On the fleeing and attempting to elude, that's 5,000. On the misdemeanor possession of marijuana is 500, failure to use turn signal is 500, willful obstruction of a law enforcement officer is 1,000, and driving while license suspended or revoked, that's going to be 1,000. His total bond is going to be 5, 6, 7, 8. That's an $8,000 cash bond only. Mr. Fleming has received surety bonds in the past and apparently is still shown a very high likelihood to reoffend. So the bond will remain on a cash bond status only. He is not allowed to operate any motor vehicle, and he's not allowed to consume any alcohol, no illegal drugs, no further contact with Jan Gilliam after today. And his next court date is going to be July 11th. Yes, sir. Mr. Fleming, you have a
Yes, I just have a quick thing to say. Like, I've been in the house for 4 months, and the reason why I got an FTA because I was in the hospital. Like, I literally haven't been outside at all. Yesterday, the only reason why I was outside because I was with my baby mom's cousin, the defendant, and he wanted me to tour him around the city, and I took him to Waffle House, and on the way back,
Mr. Fleming, thank you. Now you just admitted to operating a motor vehicle while your license suspended revoked. Like I said, you have open cases with surety bonds, and you have still not understood that you cannot violate the law while you don't have a valid driver's license. And on top of that, with the alleged chase involved, I believe that you are a tremendous threat to the community. So your bond is set at I miscalculated. That would be a $9,000, no, I'm sorry, it's 8,000. It's 8,000 cash bond only. Reset date is July 11th. But please don't say anything else until you speak to your attorney. I believe that you might subject yourself to self-incrimination. Your next court date is July 11th. Please understand that from this moment onwards, you are not allowed to operate any motor vehicle until further order of the court. It doesn't matter whether the Department of Driver Services gives you a driver's license, you're not allowed to drive.
I respect it.
Thank you. Appreciate it. Next court date is July 11th.
Next, we can go to position number 13, Robert Rooks.
Okay. And the Miss Champion, please note that if he makes bond, he has to be released to the Rockdale or APD hold only.
Yes, ma'am.
And could you give me that name again? Was it Mr. Kennedy?
Robert Rooks, position 13.
Oh, got it. Mr. Rooks is accused of giving false information to an officer and willful obstruction of an officer in case 24 CR 3976C. Alleged date is June 17th, 2024. Mr. Rooks, you've been advised of your right to remain silent, and your attorney is Ms. Kim. Any priors, please?
Yes, Your Honor, this is the defendant's 7th arrest. The last arrest was October 1st of 2023 for possession of a controlled substance with intent to distribute, which appears to be an open case. The defendant is on probation for 2 cases. The defendant is serving an 8-year sentence on probation in Rockdale County for possession of a controlled substance with intent to distribute. And the sentence date was July 10th of 2019. Also, it appears that the defendant is serving a 3-year probation sentence for possession of a firearm by a convicted felon and possession of a possession of a controlled substance. The sentence date is January 11th of 2022. The defendant meets the criteria for level 3. Nothing further.
All right. Does he have any probation holds?
Not that I could see.
All right.
Okay. Officers were conducting a traffic stop when the defendant gave them a false name of Damon Dawson and a false birth date of January 23rd, 1994. When officers asked the defendant what his middle name was, he continuously refused to tell them and would not step out of the vehicle when asked to do so by officers. The state is recommending a signature bond through pretrial services, no drugs, weapons, or alcohol while out on bond.
Miss Kim, I don't have a problem with the signature bond. I just want to be sure he doesn't have any probation holds. I didn't see any holes. Miss Washington, would you agree?
I was scrolling through the GCIC. Give me one more moment. I see no holds.
Yeah, I just wanted to confirm that. There wasn't any on the jail screen, so on
I'm
the
sorry.
giving, sorry, go
I'm
ahead.
sorry, I do apologize. The hold that I'm seeing is from Texas, and that was from 2017.
Okay, but it's not holding him at the jail, so I just want to be sure of that. On the
Yes.
giving false name is going to be 1,500 and the willful obstruction is 1,500. This is a $3,000 signature bond through the jail. Mr. Brooks, you currently have a signature bond. You don't have to report to pretrial, but this is an open active case. So from this point onwards, it would be to your benefit to make sure that you have a current mailing address with the court and that you come back to court when summoned, because otherwise a bench warrant will issue for your arrest and your signature bond will be revoked. Thank you.
Thank you.
Can you repeat the bond amount, Your Honor?
1,500 on each count, $3,000 signature bond through pretrial to, not to pretrial, through the jail, and to update us with his current mailing address.
Next, we can go to position number 1, Oshara Davis.
All right. Osahara Davis is accused of criminal trespass at 24 CR 3964F from June 19th, 2024. Who's the prosecutor in this matter?
I
Ms.
think some
Myself,
things,
Your Honor.
All
I
right.
think some things
Cook
have
is the
changed
defense.
on this, in this afternoon. Is that correct? There's.
I'm going to find out. So,
Okay.
Mr. Davis, you have been advised of your right to remain silent, and your attorney is Mr. Cook. Yes, Ms. Folk, I know the battery has been NOD'd. Anything else?
Well, okay, so there were actually 2 family violence battery cases, Your Honor.
Okay.
One from back in 2021. That was the case we NOD'd. Then there was another family violence battery from May 23rd of 2024. That case has been accepted for transfer to the DA's office and is being placed on tomorrow's felony first appearance calendar. It is not a Riverside issue.
All right. And what is that case number, if you have it?
Let me see if they've given it a case number. I actually got the email confirming the transfer while we were in court. So I'm not sure if they have given it a PI number at this point, but let me
All
just
right.
double check. They have not yet.
Okay. Ms. Washington, any priors on Mr. Davis?
Yes, Your Honor. This is the defendant's 5th arrest. The last arrest, from what I could understand from everything, was October 6, 2020 for 2 counts of reckless conduct, battery, and 2 counts of aggravated assault, which appeared to be reduced to 2 counts of battery. The defendant is currently serving a 3-year probation sentence in Fulton County for battery. And that case number is 22 SC 180334, and the disposition date was October 6th of 2020. And it also appears that there was a misdemeanor conviction in January of 2020 for battery family violence out of Fulton County. That case number is 20CR00472J. And also it does appear that there was an open case in Fulton County for aggravated assault with deadly weapon, aggravated assault, family violence, battery family violence, reckless conduct, battery, and possession of a firearm during the commission of a crime. And that case number is 22 SC 185055. And the defendant does meet the criteria for level 3. Nothing further.
Ms. Davis, what's the state's recommendation?
Your Honor, just to kind of clarify something, that 180334 case,
Mhm.
defendant was actually convicted of aggravated assault under first offender probation. He was given 3 years probation, and he was required to complete FVIP, and then given 12 months probation concurrent to count 2. The other aggravated assault was then reduced to a reckless conduct. That sentence was October 6th of 2022. I'm not sure if he completed the terms of first offender probation, but it does not look like his first offender probation has been closed out at this point. It is still showing as open in the jail, in the clerk's screen. I will state that in this particular case, on June 19th at 81 Allen Temple Court Northwest, Jamia Carlisle stated that the defendant, her boyfriend, cut her work uniform and her air mattress with a pair of scissors due to him not getting a Father's Day gift in a timely fashion. This is in addition to the case that was transferred, also involving Miss Jamia Carlisle from May 23rd, 2024, where there was a physical altercation that resulted in Miss Carlisle suffering a busted lip when the defendant punched her in the face. Ms. Carlisle resides at the location with the defendant. She has stated to police on this incident that she did not have anywhere to go, cannot get her own place of residence. We did attempt to make contact with Ms. Carlisle and would like to sound for her at the conclusion of this recitation of facts. We sent text to both of the numbers that we had listed for her. As you have already heard, we have that 2021 conviction for family violence battery that did involve a different victim. And that case is the basis for the May 23rd, 2024 family violence being upgraded. Currently on first offender probation on that aggravated assault, family violence, and reckless conduct, again involving a different victim. And we are, based on this, asking for a $10,000 surety bond, stay away from 81 Allen Temple Court Northwest, and no further contact with the victim, in this case, Miss Jamia, Jamia Carlisle, Carlisle. We are also asking if the defendant has not already done so that he must complete family violence intervention program as a part of his bond. That's all for the state. And we would like to sound for Miss Jamia Carlisle if she is here.
She's done. Mr. Cook?
Yes, just so I'm clear, we've then now gotten down as far as a state court to criminal trespass and damage to property. Is that what's left here?
That is correct.
One count, criminal trespass causing damage to property.
Okay. We would then be seeking, we would ask the court to follow the recommendation of pretrial. We have no problem with a stay away or no further contact, but we would be seeking a signature bond at level 3.
Yeah. Bond is set at, yes, courtroom 2.
I'm sorry for interrupting, but I just wanted to say 81 Allen Temple, my deceased mother was staying there and my sister has taken over. So it's currently where that's why I go and help take care of my sister and stuff. So I don't know why they saying trespass, because I was there with my sister. That's her residence. So it's like I have to go there and make sure she's all right, help her pay her rent and stuff.
I'm not sure what this is 81 Allen Temple Court.
Yes,
right?
ma'am.
Okay. On the criminal trespass, your bond is set at $2,500. It is a surety bond. You are to have no further contact with Jamia Carlisle. You have to stay away from 81 Allen Temple Court in Northwest Atlanta as long as Jamia Carlisle occupies that property. If she no longer occupies the property, then you may return to the location. You may go back there one time only with a police officer to verify that she does not live at that location in order to return there. You're not to consume any illegal drugs, no alcohol, and you're not to possess or own any firearms. Your next court date is going to be July 11th. Yes, sir.
Yes, can I say she has left the residence like day of whatever going on. I got arrested. She left the residence with her mother. So I'm pretty sure she left the residence.
As I said, the first time, once you make bond, you can go back to that location one time only with a police officer. If the officer verifies that Jamia Carlisle does not live there, then you may visit the property. Within 30 days of being released, you must update the court with your own current mailing address. Presently, you still have a felony hold because your battery charge is going to be addressed at the felony first appearance tomorrow morning at 11 o'clock. Thank you.
Your Honor, both of the battery family violence were dismissed, right? NOD.
One was dismissed and the other one has been transferred to felony first appearance.
Okay.
And Ms. Falk, if you want to give me the incident dates of the ones that's NOD'd and the one that's going to be transferred.
Yes, Your Honor. The one that will be transferred, the incident date is May 23rd of 2024. The one that was dismissed, the incident date is October 17th of 2021. And I did send that NOD to the jail and the jail staff as well, indicating which specific warrant should have been dismissed and which one will be which one remained.
Okay, thank you. Do we have a Dennis Dupree?
Yes, he's in the chair currently.
Thank you. Mr. Dupree is case 24 CR 3965A, accused of simple battery at the Centennial Olympic Park on June 18th, 2024. Mr. Dupree, you have been advised of your right to remain silent and your attorney is Mr. Cook. Any priors, please?
Yes, this is the defendant's second arrest. The last arrest was June 17th, 2018 for possession of marijuana less than an ounce. There appears to be a hold from 2018 for an FTA with Jonesboro Police Department, and the defendant does meet the criteria for level 1.
Thank you. Ms. Falk?
Yes, Your Honor. This happened June 18th, 2024 at Centennial Olympic Park. Officers did observe an argument in progress.
I'm sorry, just 1 second. Yes, sir, I do see your hand up and I will address you shortly. Please put your hand down. Sorry about that, Ms. Falk. You have officers observed?
Right. An argument in progress approached, talked to a bystander who stated they saw the defendant hit Malcolm Johnson, who's a hot dog vendor, in the face. The officer did talk to Malcolm Johnson, who stated he couldn't see who punched him, but the punch caused him to stumble backwards. However, Harold Struckey, who was a witness, an eyewitness, stated it was the defendant and described what he was wearing. The defendant did admit to punching Mr. Johnson, claiming they were in an argument about the cost of a hot dog, and Mr. Johnson threw water at his brother, so he punched Mr. Johnson in the face. We have tried to make contact with Mr. Malcolm Johnson, did leave him a message and send a text. We are asking for a signature bond through the jail, no further contact with Malcolm Johnson, stay away from Centennial Olympic Park, as well as one-day anger awareness, and no alcohol, drugs, or weapons. That's all for the state. We would like to sound for Mr. Malcolm Johnson.
Right, he's not here. Mr. Cook, this is going to be a 1,500 signature bond through the jail. No further contact with Malcolm Moses Johnson. He's to stay 200 yards away from the entire location known as the Centennial Olympic Park. He's also not to consume any illegal drugs, no alcohol, and not be in possession or own any firearms. His next court date will be sent to his current mailing address. Since he has a Jonesboro hold, once he is released on the signature bond through the jail, he will be released to the Jonesboro PD hold. Mr. Dupree, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. If you decide to waive your right to remain silent, then you are free to speak up.
Mr. Dupree, you've just received a signature bond through the jail. Don't say anything further. You've got exactly what you need to proceed with your case. We're not going to drop your case today. We're not going to adjudicate your case today. Just say nothing further.
I don't have a background though, sir. I never been locked up, never been on a hold, none of that.
All right. It appears that you do have a Jonesboro hold. There might be an outstanding warrant against you. So that once you make bond, you'll be released to that hold and then you can try to resolve it there. Thank you.
One question for, I guess it's pretrial. He is 19 years old. That shouldn't be a problem on a signature bond through the jail, should it?
No, it's not through the jail. It's not.
Okay, thank you.
All right,
If we could go to position number 9.
yeah, Rolando Kennedy. Does the public defense have any waivers today, or I've got just a couple more cases? All right, this is Rolando Kennedy for case 24 CR 39728. Mr. Kennedy's got 2 charges stemming from June 19th, 2024. Criminal trespass and violations of certain rules at a bus, rail, or station. Mr. Kennedy, you've been advised to be a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney and your counsel's Ms. Satay. Any priors, Ms. Washington?
Yes, this is the defendant's 9th arrest. The last arrest was January 26th of 2022 for willful obstruction. It appears that the defendant received first offender treatment in 2013 for burglary, and that was sealed in 2017. There's a 2017 misdemeanor conviction for simple battery, family violence, a 2017 arrest for aggravated stalking, burglary first, battery, family violence, and obstruction of a law enforcement officer, which was dismissed. A 2019 arrest for criminal trespass, which was no price. A 2020 arrest for 2 counts of simple battery and criminal attempt, which appears to be a dormant case. 2 FTAs, one in 2015 and one in 2018. And the defendant meets the criteria for level 3. Nothing further.
Thank you. Ms. Mulcahy?
Yes, Your Honor. The defendant is accused of unlawfully entering the Hamilton E. Holmes MARTA station without paying the required fee, while simultaneously having a 60-day suspension from MARTA, which is set to expire on July 31st, 2024. The state is recommending a signature bond through pretrial services, stay away from all MARTA locations, and no drugs, weapons, or alcohol while out on bond.
Mr. Cook, you do realize your client has an open bench warrant in 23 CR 006491 before Judge Roth.
Your Honor, yes, this is my client.
Oh, I'm sorry, Mr. Tate, that's what I meant.
I've gotten in
Yeah.
touch with his attorneys that are in Judge Roth's courtroom. They're gonna be in touch with the clerk or the court on Monday.
Okay, all right. Yeah, go ahead.
I don't object to the signature bond through pretrial services. I would prefer it to be through the jail. I understand there's history, but a lot of, the 2017 was dismissed. Your Honor, my client is 31 years old. He has lived in Georgia all his life. He states that he graduated from high school in 2014. He is disabled. He suffers from autism. I believe he was in the special education program at his school until he was 21 years old, at which time they don't have a program for them anymore at the school. He states he was in class with 4 people. He has tried to work part-time, but he states that he was not able to keep his job at Kroger. He does, sorry. Yes, in order to keep his benefits. He can't read and write. And I did see that I mean, I can't do anything about the FTA now, but I'm working on that. But I would just ask for a signature bond through the jail. I do believe reporting to pretrial services does place a burden on him that is not the same as other people.
Huh? On the criminal trespass, that's going to be $1,000 signature bond through pretrial services. On the violation of certain rules, that's going to be $500. His total bond is $1,500. Signature bond through pretrial services level 1. He's to stay away from all MARTA property in accordance with any active suspension. So at the time of the arrest, he had an active suspension through the end of July of 2024. We're still in the middle of June. I don't know whether his suspension has been extended as a result of this new arrest. So he cannot use any buses or trains or be at any of the stations until further order, until his all suspensions are lifted.
Okay, so I'm sorry, Your Honor, you're not requiring a stay away from MARTA. You're just saying abide by any MARTA suspensions that there are.
Correct. And right now, at the time of the arrest, the suspension is until the end of July. But I cannot speak to whether an additional suspension has been imposed as a result of this new arrest. I'm going to reset this case to July 11th, along with 23 CR 0064991A, which is his bench warrant. And these two cases are going to be further noticed to July 11th. Since it can't be released on his signature bond pending the bench warrant.
So she changed it.
Thank you.
But it's still, he has FTA. So unless it's still a signature. We could go to position number 10, Mr. Moore.
This is Dondre Lamont Moore, case number 24 CR 3973E, accused of battery with respect to a Terriona Williams from January 3rd, 2024. Mr. Moore, you've been advised of your right to remain silent, and your attorney is going to be Is it Miss Ate?
Yes, she right here.
Okay, thank you. Any priors, Miss Washington?
Yes, this is the defendant's 11th arrest. The last arrest was July 15th of 2023 for 2 counts of simple battery and cruelty third, which does appear to be an open case in Cobb County. There's a 2007 arrest for 2 counts of simple battery, which appeared to be null price. The defendant received first offender treatment in 2010 for burglary, theft by receiving stolen property, and willful obstruction. That was sealed in 2018. The defendant appears to have 2 open cases, one being a traffic matter in Fulton County for no proof of insurance, a 2021 dormant case for DUI, speeding, reckless driving, and also a 2012 FTA, and the defendant does meet the criteria for level 3. Nothing further.
Thank you. Miss Ate?
Do you want me to present first, Your Honor?
Oh, I'm so sorry, Miss Mokeke. I'm so sorry. Go ahead.
Officers met with the victim in this case, as you stated, Ms. Terriana Williams at Northside Hospital. She stated that her and the defendant are co-workers, and the defendant is one of the managers at the Kroger that they both work at. The victim stated her and the defendant met up to hang out in his car. The 2 parties had a disagreement, and that is when the defendant climbed into the back seat and began to strike the victim in the face and chest with his hands. In self-defense, the victim did hit the defendant with a small tray that was in her lap and then bit his arm so that she could exit the vehicle. The defendant followed her out of the vehicle and pushed her backwards, which caused the back of her head to hit an object. There were 2 other unknown individuals in the vehicle at the time, and the victim did sustain swelling to her eye as a result of the attack. Given the defendant's violent history, the state is recommending a $3,000 surety bond, no further contact with the victim, no drugs, weapons, or alcohol while out on bond, and also anger awareness.
Oh, Miss Ate, go ahead. I just want to also mention he's got a bench warrant from Judge Morrison.
You have an FTA.
For what?
2 counts of DUI plus a whole bunch of other traffic matters in case number 23 CR 002-703A. A bench warrant from July 3rd, 2023 is $5,000 surety.
No.
Oh, okay.
Yes, Your Honor, I do see the FTA, and okay, so Your Honor, my client is 35 years old. He has lived in Georgia for 20 years. He has a 13-year-old child. He is gainfully employed. He was working 2 jobs, one at Kroger and then at Tin Lizzy as a chef, where he's been working for 2 years. He did graduate from high school and attend college. He firmly denies the allegations as stated in the warrant. He states that there were other people in the car who would be witnesses for him. In the warrant, the complaining witness does not give their names. I think it's because she knew that they would state, would not corroborate what she is saying, but my client does have witnesses. He wasn't given a chance to make a statement. This happened in January, so more than 5 months ago. More than 5 months ago. He does deny the allegations as stated in the warrant. He states that he acted solely in self-defense. She threw a tray in his face. He only exited the car to get her out of his car. She bit him. He did sustain injuries. He is fine with no further contact and a stay away. He doesn't work with her anymore and has no reason to see her and has not seen her. I understand there is history, but there's an open case. Other than that, I didn't hear any history that was violent, Your Honor. And he does not have any violent convictions on his record. He's not a flight risk. And I would ask for a signature bond. He is recommended for a signature bond through pretrial services at level 3.
So he's got a Cobb County open case and this DUI case, and he's got FTAs. Bond is set at $1,000. It is a surety bond. No further contact with Terriona Williams, and his case is reset to July 11. In addition to the other case, 23 CR 0027038. So we're going to reset both cases to July 11. Thank you.
We can go to position number 12, Mr. Dayan Rhodes.
Could you give me that name again, please?
Mr. Rhodes, position 12.
Oh, Rhodes, yes, okay. This is Dayan Rhodes, 24 CR 3975J, accused of theft by taking and criminal trespass at the Georgia Tech properties, the Graduate Living Center, from June 16th, 2024. Mr. Rhodes, you've been advised of your right to remain silent, and your attorney is Ms. Kim. Any priors, please?
Yes, Your Honor. I do want to note that the defendant was on the behavioral health list this morning. This is the defendant's 7th arrest. The last arrest was May 27th of 2024, which the defendant pled no to theft by shoplifting and appears to be serving a 3-month sentence on probation. The defendant was arrested in 2023 for criminal trespass by Georgia State, which appears to be open. Another 2022 arrest for criminal trespass, disorderly conduct, and cruelty in the second, which was dismissed. A 2022 misdemeanor conviction for criminal trespass with Georgia Tech. The GCIC does show a hold from 2021 with Villa Rica Police Department for an FTA. And the defendant does meet the criteria for level 3. Nothing further.
All right, thank you. Ms. Mulcahy?
Yes, Your Honor. The defendant is accused of taking a Denali bike and tire wheel belonging to Nargis Moemi from the bike rack on campus. The defendant has a criminal.
I apologize.
That's all right. Okay, go ahead, Ms. Mulcahy.
The defendant has a criminal trespass from Georgia Tech that was issued on March 8th, 2022, and is set for 5 years. The state's recommendation for the theft by taking is a $1,500 surety bond. For the criminal trespass, it is a $500 surety bond. Stay away from Georgia Tech campus. No further contact with the victim, Nargis Moemi, I believe that's how you pronounce her name. No drugs, weapons, or alcohol while out on bond. And as pretrial mentioned, the defendant has been referred to misdemeanor MH court.
Okay. Ms. Kim? I'm sorry, Ms. Kim.
Yes, my client is 22 years old, young, and actually Yeah, he is residentially challenged, so I was going to ask social worker to have a visit, and since he's already at MH calendar, maybe he can be put for competency calendar, and I was hoping that he may also be referred to PAD. However, we don't have that right now. He graduated from high school at Martin Luther King Jr. High School. He said he played basketball player with a C average. Signature on bond through pretrial will be most desirable. Thank you.
It's $500 on each count. The total bond's $1,000 surety to stay away from all Georgia Tech property, no contact with Nargis Moemi. And we're going to, yes, Mr. Rhodes, I'm going to hear from you shortly. Please put your hand up. And we're going to reset both cases. The first one is the one on our calendar. The second one is 23 CR 005817J. Both cases are going to be reset to, I don't know if July 11th is a, yeah, we do have July 11th at 11 a.m.
Thank you.
Please unmute courtroom 2. Mr. Rhodes, you have a right to remain silent. Your attorney, Ms. Kim, has spoken on your behalf. So if you'd like to remain silent, that way you will not be incriminating yourself as well as making it easier for your attorney to represent you.
Your Honor, can you repeat the bond amount before?
$500 on each count, $1,000 surety. And we're going to reset that case and his other open case, 23 CR 005817J to July 11th.
Did you want to talk?
All right. Any other cases, Deputy?
No, Your Honor, that was all.
Your Honor, actually, I also have.
Yes, you're on mute, Miss Kim.
Your Honor, I apologize. I just realized that his case is also, for the record, should be considered as a Riverside. He was arrested on Tuesday, June 17, 9:50 a.m. So it's actually almost 6 hours away later. So
Okay, I looked at that. He was booked in on June 19th.
but arrest was June 17th.
Okay. I don't know why I thought it was in Riverside. Let me see.
Georgia Tech Police Department arrested at June 17, 24, 9:50, and they brought him to Fulton County yesterday.
I have June 19th, 2024 at 12:27 p.m. according to the ticket, wanted person.
No, Your Honor, I do have a booking report clearly says that it was June 17th, 9:50 a.m.
Yes, the warrant was June 16. The warrant was taken out June 17. So you have information that he was booked in by Georgia Tech on June 17th?
Yeah, it's at the booking report, Your Honor.
Okay.
Yeah.
And the warrant was issued on June 19th, so that's a 72-hour hold. Has it been more than 3 days? I don't know. Ms. Falk, I don't have the information. Do you have anything to verify that?
Right. According to the arrest date on the jail screen, it does say June 17th, 2024 at 9:50 a.m. So I believe this would have to be converted to a signature bond through pretrial services.
No, it's converted to a signature bond through the jail, but he's still, yeah, then if it is Riverside. So you all have June 17th then? Because I don't have that.
I do have it on the jail screen under booking 2410265.
Okay, then it will have to be a signature bond through the jail. And he needs to stay away from all Georgia Tech property.
Thank you.
Thank you. that concludes our roll call. Okay, on position one, Davis is a $2,500 surety bond, reset July 11th. Position two, Duffy is a $2,000 surety bond, reset dates July 11th. Position three, Dupree is a $1,500 signature bond through the jail. But he's got a Jonesboro hold, so it's a release to the Jonesboro hold only. Position four is a $8,000 cash bond only, reset date July 11th. Position five, Freeman is a signature bond, $25,000 signature bond to pretrial level 3. Position six, Grant is a 17,500 signature bond through pretrial services level 3. Position seven, Harris is a 2,500 signature bond through pretrial services. Position eight, Eugenia Harris is a 2,500 signature bond through pretrial services. Position nine, Kennedy Rolando is a 1,500 signature bond through pretrial services. Reset date is July 11th because of his bench warrant case. Position 10, Moore is a $1,000 surety bond. Reset date July 11th along with his bench warrant case. Position 11, Payton is a $2,000 signature bond through pretrial level 2. Position 12, Rhodes is a that's been amended to $1,000 signature bond through the jail based on Riverside. Stay away from all Georgia Tech property. Position 13, Rooks is a $3,000 signature bond through the jail. And position 14, Scruggs is a 3,000 signature bond through pretrial level 2. And position 15, Walker is a 2,500 signature bond through pretrial services. Any questions? Any changes?
Yes, Your Honor, I do need to address something that happened on Tuesday with Judge Morrow that was concerning one of the defendants that was released to pretrial.
May I have that case number?
Yes, it's 24 CR 003-859E as an elephant.
Oh, okay, it's not.
You mean
Give me that case number.
895E? Did you mean that?
24 CR 00.
385. I'm sorry, I gave the wrong number. 895E as an elephant. So
895E. Okay.
Mhm.
All right, courtroom 2, I think we're concluded. Thank you so much. And anyone else who's not involved in this case, you are free to go. But I'm trying to pull up 24 CR 0089.
5E as an elephant.
5E, and I'm missing one extra 0. Maybe I can't type. Try it again. 24 CR 000.
No, you're missing no extra 0. So it's
Okay.
2 zeros.
Okay. 838, was it?
38. 3895E.
Okay. Okay, theft by shoplifting and battery, and the release order indicates a $500 signature bond through pretrial and a $1,000 signature bond through pretrial level 1. Yes, what's the to be released to something, Tina, Chris?
Yes. So Judge Morrow ordered that the mother, Miss Cross or Chris, was to pick him up from Riverside. However, the mother is refusing to pick the defendant up from the jail. So we're trying to figure out what we need to do, and we just needed further instruction on who needed to
Any
pick him up.
indication why she's refusing?
Not that I know of. I just received word that she was refusing, and I was in misdemeanor that day with Judge Morrow, and he just agreed to do a pretrial because the mother was supposed to take him to River Edge, because he had already had a bed there, from what I understood.
Okay. And how old is he?
I'm not sure. Hold on a second.
He is 28.
1995, 28, 29?
31, 30 or 31. Yeah. something
No,
like
it
that.
can't be 31. He's born in 1990.
No, he's definitely 28.
Sorry, my
He
math is
turns-
not the best.
Yeah, he
That's
turns
okay.
29 in October.
Yeah.
It looks
Okay.
like.
Yeah.
So
20
I thought it was a cosigner, but it's not.
No, that was my case. The agreement was that Miss Chris would pick him up from the jail and deliver him more or less immediately to River's Edge, where he was, we were told, not by River's Edge, I don't believe, but by him and Miss Chris, that there was a bed waiting for him.
All right.
So Your Honor, I am speaking with the victim advocate who was present on the day of the hearing. Apparently, Miss Chris was not at the hearing. The defendant's mother was actually not there. These were representations that were made by the defendant's counsel, that she would be taking him to River's Edge, but she actually was not present in court to consent to that. So it looks like maybe some promises were made that can't be backed up by the mom because she has no intention of picking him up and taking him anywhere.
Mr. Cook, have you reached out to anyone else in the defendant's family?
No, I was not aware of this until this moment, so I have not.
And is River Edge a facility that they could have someone from their a representative from their company or their agency come pick him up?
I don't know enough about them, but I can certainly check with River's Edge.
Okay.
And it would have to, I know the jail would need a name for who exactly will be coming to pick him up, or else they're not going to release him to a person.
All right. Well, typically he's over the age, and it looks like a recommendation has been made for a social worker visit. So I don't know if there's a mental health or behavioral health issue. And I don't know whether he is able to transport himself or is cognizant on how to transport himself. Mr. Cook, you've spoken to him. Can you give us some insight?
There was a social worker visit scheduled. I don't know if they have done that yet. There were some MH concerns. That's why he was going to River's Edge. So again, I can do some digging, call River's Edge, and try to contact the family, but I was not aware until this moment that there had been a glitch.
Well, he qualified for pretrial. I don't know what his criminal history is. What is his criminal history? Miss Washington or someone can give me some background. So, I mean, someone's asking me to amend the bond or leave it as is and give him a new court, SAP court date pending his release.
Your Honor, the defendant has 34 cycles. The most recent arrest previous to this one was May 8th, 2024. Theft by shoplifting and possession of methamphetamine out of Atlanta. There was an FTA of February 17th, 2023 out of Brookhaven. A dismissed family violence, battery, criminal damage to property, November 17th of 2022 out of Fulton County. I'm showing a February 25th, 2022 arrest for theft by shoplifting in Fulton County, but it does not show the disposition. An October 1st, 2021 arrest for criminal damage to property in the second degree in Fulton County does not show a disposition. A July 31st, 2021 theft by shoplifting arrest in Atlanta does not show a disposition. May 23rd, 2021 failure to appear. April 19th, 2021 failure to appear.
No, that's good. Thank you, Ms. Paul.
Yes, Your Honor.
Miss Washington, I can give you, I can let you know that right now, I'm going to allow this bond order to remain in place. And if Miss Chris has a change of mind, she can come pick him up anytime she wants. Because the requirement says to be released in order for him to go to River Edge where he can live there and we have a definitive address. But I can give you a new SAP court date of July 11th. And Ms. Champion, I don't know if you were the case manager at that time.
No, ma'am, I was not. It was Miss Holly.
All right. Can we do a reset date for this case to the
Yes.
next SAP calendar? On Tuesday, was it still July 11th?
Yes, ma'am.
Okay. July 9th was not available?
Let me check and see how many is on that calendar.
The reason being typically Tuesdays are Judge Morrow's days, so he would have more familiarity with this case. So Ms. Washington, please keep the release. She has till July 9th or 11th to pick him up and take him to River Edge.
Okay.
And then in the meantime, he definitely needs to be seen by the social worker. And if Mr. Cook, if he needs to be evaluated, he needs to be evaluated.
Yes, I made that request on the 18th, and I'm going to be on the phone here just in a moment to Miss Chris to see, what her feelings are.
All right, thank you.
Your Honor,
we
also,
I'm sorry. We actually can put them on July 2nd, which is the Tuesday before the 4th.
Even better. July
Your Honor,
16th, okay.
So as not to misrepresent anything to the court, I do want to let the court know, after looking at his history, I was also not present when this case was addressed, but after looking at this defendant's history, this should have been upgraded to a felony. He is beyond 3 convictions for theft by shoplifting. He is actually a repeat offender at this point in the superior courts. And so
Understood.
for that reason, I am making the request.
I understand your position. I'm not going to get any further into the case because he's not present. The only
Understood, Your
thing we
Honor.
have is the release. So between now and July 2nd, if the solicitor's office has a different approach to this case, they are free to do so. But
Thank you, Your Honor.
presently, Ms. Washington, I hope that answers your question. Pretrial can interview him, but they can't release him because you don't have the next element for release.
Right,
So
which
we're
is
going to give him a court date of July 2nd, and we'll see what happens at that time.
okay. Thank you.
All right, everyone. Any other questions? Okay, y'all have a good Thursday and see you tomorrow. Thank you.
Bye.
Thank
Thank
you.
you.
Thank you.
Thank you.